Okay, hello everybody. I am delighted to introduce our speakers today for cross-examining experts in medical malpractice litigation. Oh, I think Ben already started screen sharing, which is fabulous. So our speakers today are Michelle Hemesath and Benjamin Ikuta. Michelle is a founding partner at Ikuta Hemesath, LLP. Michelle's practice is focused on representing injured victims and their families. She began her career representing healthcare providers and learned from some of the best defense attorneys on the West Coast. During this time, Michelle gained invaluable experience and intimate knowledge of how insurance companies handle lawsuits, how to best position a case for trial, and how to wade through complex medical issues. Benjamin Ikuta is an ABOTA member and a founding partner at Ikuta Hemesath LLP. Ben focuses on cases of medical malpractice, elder abuse, and personal injury. He is a preeminent attorney in prosecuting medical malpractice actions and has tried multiple cases to verdict. He has presented and been published many times on medical malpractice issues. Ben handles complex medical malpractice actions typically involving serious injury or death. Since 2016, Ben has secured 10 seven-figure settlements and 58 six-figure settlements. He has multiple plaintiff-sided jury verdicts in medical malpractice actions. And in total, since 2016, Ben has recovered a staggering over $113 million on behalf of his clients. And just on a personal note, I have come up against Ben and Michelle numerous times as adversaries. They are formidable adversaries. They are extremely experienced and knowledgeable. I'm looking forward to learning from them today. And so I will hand it over to Michelle and Ben. Thank you both for being here.
Thank you. Well, don't learn too much, please, since you're against us quite often. So thank you, everybody, for watching our presentation. And I see the attendees, a lot of impressive med-mal lawyers in there. So please ask questions. I don't want to just hear ourselves talk for the next hour. So ask questions. We'll answer them right away. I think it's really important that we have questions and answers.
I was already checking. Nobody's asked any questions yet.
No open, no questions yet. All right.
All right, so our first slide is on a very basic jury instruction, KC 502. For those of you that do medical malpractice, you know that 502 is the standard of care. The last bit here in the bracket says, you must determine the level of skill, knowledge, and care that other reasonably careful doctors would use in similar circumstances based on the testimony of expert witnesses.
Based only on the testimony.
Remember that it is only on expert witnesses. And in the brackets, it says including and then name of defendant. And so it's important in medical malpractice cases that sometimes defense counsel will designate their client, the defendant, as an expert. If they are designated as an expert, you should notice their deposition, and then defense counsel will normally say, we're withdrawing them as an expert. Make sure that when they say we are withdrawing them as an expert, that you say, great, just understand that KC 502, you will not be allowed to put in including the defendant, because the defendant will not be an expert witness because they were not designated as an expert witness.
Yeah.
Anything else you want to add, Ben?
Yeah, that's really important. A lot of defense lawyers try and sneak in that bracket. And, typically speaking, doctors and nurses make good witnesses, and they want to give them extra credit here and use this against us. So really, really important that if they designate their clients as experts, you notice their deposition as an expert. And to be clear, if that happens, they waive the attorney-client privilege under a case called Shooker versus Superior Court. And so not only should you seek the deposition, but ask for all communications between the defense lawyer and the defendant, as well as the insurance carrier. Because again, the attorney-client privilege is waived. And so really important you get that little bracket out all right? Super important in trial, all right? And look out for that when you guys exchange jury instructions.
And if you want to look at a sample a sample deposition notice on how you can ask for that type of communication, you can email us at the end of this and we'll give you the example of a deposition notice with a request for production of documents that specifically cites the type of information that you are entitled to receive.
So a bunch of words that just means experts are important in med mal cases.
We do have a question already, though.
Well,
Here.
it's Rachel's question. We can get to it later.
Okay, sorry.
All right, this
Rachel.
one's really important. Go over this one.
Okay. So I think that oftentimes there is a little bit of confusion in the community about when you can use a defense expert in your case in chief. Okay, and so there is a code 2025.620 subdivision D. And this allows you to play the deposition testimony of an expert witness. You don't have to show that the expert witness was unavailable, okay? You can take their deposition. We videotape every single deposition that we take, and especially of experts, when we videotape those depositions, we try to get nuggets so that we can play those at trial. And even if we don't get something great for us, we will play that, hey, defendant thinks that the defendant did everything within the standard of care and that, it didn't cause any harm. We still play that in our case in chief so that our experts can address what the defense expert is going to say. You will hear oftentimes, oh, you can't do that. Well, yes, we can, and it is not cumulative. It is permissible. We don't have, I've heard a defense attorney tell me one time, well, then you can't use your own expert. That's a silly argument to make. Our experts are clearly going to be saying two different things, and so it's not cumulative, and I don't have to pick your expert over mine. You just need to designate that testimony, and you need to put in your notice of the deposition the code section that says you intend to play it at trial.
We play every single defense expert's deposition, at least part of it, small nuggets, in all of our cases. And in all of our cases, the defense has every single time raised a fit, despite the extremely clear language of the statute, which says any witness, any expert witness. And we've always prevailed in this issue because the statute says what it says. All right. There's also two other cases. Powell held that it was error to not allow the plaintiff to call in their case in chief a defense expert. And oftentimes it's very common with the damages experts because they'll make critical concessions about your client actually being injured or actually having a lot of problems. And it's not uncommon. And I think defense lawyers will admit this. Oftentimes they won't even call their own experts at trial. So you need to get ahead of the ball and call them in your case. All right. And the best way to do that, the most cost-effective way to do that is to just play their depositions. All right. So very, very clear that you can both call and play opposing experts in your case, and you should. Okay.
Yeah, so I think the only last thing to add there is that when you are taking these depositions, you need to make sure that the testimony that you're getting is clear. Experts will often try to get around the question that you're asking and answer some other question. And so we'll talk about that a little bit more in more detail on in our next slide.
We went over the first 2 points already.
Okay.
You know, I think points 3 and 4 are really important. And I'm going to tell a story. It's an important story.
It's
a good one. You know, I couldn't find the clip, and I couldn't find, because it's a long time ago, this trial. But I had a defense expert who, in trial, was very polished, came in a suit and tie, very respectful. In deposition, he was a total jerk to me. And he was rude, he was dismissive, he was, you know, he was just really, really nasty. And there was one part where I said, you know, where in the records does it say X, Y, and Z that supports your opinion? He said, I'm looking at your job for you, Mr. Ikuta. Here, just look for it yourself. And in his hands, handed me a bunch of records. So rude. And I showed that part to a jury. And then when they actually saw him in trial, how two-faced he was, they hated him. And that was the only case I've ever won 12-0 on the plaintiff side. All right. So it's not always just what they say, it's how they say it. I actually, my first slide was him handing me the papers in my closing statement, how rude and how dismissive he was.
And I think that's an important point that Ben just made, is that it's a lot different when you have a deposition transcript and you're reading from it, question, what is your opinions on the standard of care? And then the answer, and then no context, you can't see the pauses, you can't see what they're emphasizing. It is so important to videotape all of your depositions. For example, I'll cut like various slides that I think, okay, this expert is gonna testify some way differently because they really shouldn't have said this at their deposition. I will have those clips ready to go at trial so that I can then play it instead of just reading to impeach them. I will have those clipped. So it's important that you have all of that ready to go and that you know which clips you want to play in your cross-examination of the expert. Yes, you should designate the testimony and play it in your case in chief, but you also should have those clips ready because you will cross-examine that expert and there will be things that they will hopefully change so that you can play those clips during their testimony. And then you can also use those clips in your closing so that you are now refreshing them on what was said. It's different when you're just clipping the testimony and they're reading it. Jurors learn different ways, and so having that testimony playing for them can be very helpful.
I agree with everything you're saying, but I'm getting bored hearing us talk. Please ask questions. Heather, I'll answer your question later. And we'll answer the question regarding qualified experts later on. Any questions, please ask us so we can break this up and answer some of them. On case-specific issues, we don't hold back. We really go after the expert. We're not rude. We're not aggressive, but we're very thorough, and we make sure we go through every single opinion in full detail and the base for that opinion and all that stuff. So on case-specific issues, on general issues, we'll go over that later. There are some things you want to save for trial, but in general, you want to really go after them in deposition so you can get those good sound bites.
And so we did talk about this a little bit, but it says experts are less prepared at deposition than trial. I mean, experts are oftentimes, they look disheveled. They will not know specifics about the medical records. I had a case where the defense expert said, oh, the patient didn't go into hemorrhagic shock until, insert later time. I'm like, well, what did you base that on? Oh, I based that on the blood pressures when the patient became hypotensive. When did the patient become hypotensive? Oh, and then they picked a time that was much later in the case. And I was able to, at trial, say, well, wasn't that patient hypotensive at this time and at this time and at this time? So isn't your opinion that the patient was actually in hemorrhagic shock at a much earlier time? So it's important that you know your own records and that you're prepared, but also understand that the defense expert or the other side's expert for defense attorneys, the experts are much less prepared at the time of their deposition. They're going to be much more polished at the time of trial.
I couldn't find the clip of the expert. This is actually a defendant in one of our cases who, wore sunglasses in deposition. And we did not bring this up during trial. We just showed it. And the jury hated him for it. We didn't win that case. We didn't lose either.
Yeah.
We mistried that case 6-6. But the 6 jurors that were on our side hated him for it. And they were actually prescription sunglasses. So it made sense for him to wear them. But, it was a bad look for him to wear these. Here's a clip of one of Michelle's depositions. You ready?
Yeah.
Oh, yeah. You want to talk about the background of this?
Sure. So I'll give you guys a little bit of background about the case. It was an elbow surgery where my client went in. She'd fallen on her elbow. The doctor severed her nerve. And so this was the defense expert that I was deposing on the issues of standard of care and causation. And so
well, no. That's the second time you deposed him.
Oh, okay, yeah. So I was going to talk about it a little bit afterwards, but so this expert, I deposed him twice. The first time that I deposed him, he said, oh, well, the nerve could have been severed during the fall. It could have been severed it couldn't have been severed during the surgery, but it also could have happened later when they had a subsequent surgery. And I said, well, can you tell me to a reasonable degree of medical probability if it was during the fall? no, I can't. Well, can you tell me to a reasonable degree of medical probability if it was during the subsequent surgery? No, I can't. And I think there might have been one other possibility, but he could not tell me to a reasonable degree of medical probability what caused this harm. So I then said I would be filing a motion in limine to preclude him from offering any testimony on the issue of causation because he could not tell me to a reasonable degree of medical probability. And so lo and behold, defense counsel says, the doctor wants to, he has some new opinions based on some new reviews, some additional things. So we're going to offer him back up. And I said, okay, well, he could have given these opinions at his first deposition, so you're going to pay for it. So they paid for it. And then I took his deposition yet again, in this case. And is that what?
Yeah, so it was a Klein versus Zimmer issue, right? Or what was the code section? 801, whatever the code section was that changed standard. It said for both sides, your opinions have to be probable, not possible, right? And so he said possible the first time around, was not prepared correctly. And Michelle really did a great job, prepared, really prepared and really went into full detail and exposed him for saying possible. And so that's why they'd offer him again, had to pay for him and our videographer and our court reporter. And here's some testimony from the second session.
Hopefully.
Dr. Gupta, I understand you're still under oath, correct?
Yes.
Did you have a discussion with anyone while we were on our break?
Yes.
Who did you speak to?
Alex,
And what did the two of you discuss?
I felt like I was being bullied and harassed. I asked him what I could do about it.
And what did he say?
Stay calm and just answer your questions as best as I could.
Was there anything else that you discussed?
No,
Is there anything else that you said?
other than I thought you were being mean to me.
I am sorry if you felt that I was being mean to you, doctor. I'm just trying to make sure that I get all of your opinions here today, even ones that you may not have realized you were forming.
And that came in because he did not want to criticize the second surgeon. And so I was asking him whether or not the second surgeon breached the standard of care. And he was just refusing to tell me whether or not he thought he said, I wasn't looking at this case for that reason. I won't be offering any opinions about that at trial. And so, I don't have the testimony here where he said, defense counsel, I said, well, why did you change your opinion that to a reasonable degree of medical probability it was from the fall? And he said, well, defense counsel told me I could not say that it was a probability or a possibility, that I had to be able to say to a reasonable degree of medical probability. Well, obviously that case settled because their expert is basically saying he changed his testimony because defense counsel told him to. So it's important that you understand the law yourself, because your expert should be able to say to a reasonable degree of medical probability that the breach in the standard of care caused X harm, right? And because if your expert can't say that, then you also have a problem. It cannot be a possibility or a probability. It needs to be to a reasonable degree of medical probability. And so this expert, because I went after him on it and I asked him a bunch of questions, he thought I was being mean to him. And so
I can emphasize like that. Yeah. Mean to me quite often. You're a bully to me. No, I'm just joking. I watched the transcript too. I mean, she was not mean. She was just very thorough, very matter of fact, and it exposed him to a certain degree, right? And he was very uncomfortable with that. And so, obviously, it shows how important preparation is, both preparing to depose experts and also preparing to defend them. Make sure that they're aware of their opinions and what they should say and what the law is. Thank you, Amber. 801.1 is the section that I was referring to, the recently amended section that states that both sides have to have probable, not possible. And Amber actually was a big part of that law being changed because Amber had a case where I think in her case, she had an elder abuse case where the defense tried to argue that a bird out of the sky hit the elder and caused her to fall, and that was a possibility or something. And anyway, so that example actually helped that law be passed, which was very helpful. So thank you, Amber, for your contribution to the plaintiff's bar. Okay, next. It's not important. Oh yeah, well, guys, this is a concluding instruction. When you are a plaintiff lawyer, especially, and you're going to show clips of the opposing experts, just ask the judge to read this during the intro. It's not the biggest deal in the world, honestly. The jurors zone out during the jury instruction readings, as do I typically. But nevertheless, just have the judge ask the judge to read this in the intro instructions instead of the concluding instructions. Okay?
And that's because oftentimes jurors
They don't know what it is.
don't know what a deposition is. They don't know that this person is under oath. So it helps if you have this instruction read before a deposition is played, just the first one or with the opening instructions.
So what we'll do oftentimes are closing. So we'll play the opposing expert in our case. Oftentimes we'll play it during the portions of it during our cross-examination of the expert in the defense's case, and we'll play portions in our closing, of course, and we'll actually show this instruction. We'll show the most damaging portions of their expert's testimony, and we'll say, really? That's their opinion? Folks, you don't have to accept an expert's opinion. You don't have to believe an expert's opinion. This is what this instruction says. So we use this instruction in conjunction with showing the opposing clips.
And I mean, and it's also that you can choose to believe some or none of an expert's testimony. And so that is helpful when maybe an expert on the other side gives you concessions. So you can choose to accept some, like we all agree on this. Or you can choose to accept none. And that would be in an instance where, they're being really crazy about opinions that they're offering. Maybe they have two experts that are offering two different opinions. Hey, their own experts can't agree on what happened in this case.
So what happened in this case, we won this case. We do win cases every once in a while. It's rare, but it happens. And it's Michelle's case, all right? And she gives a brilliant opening. It's a great job. And she has COVID in the middle of trial. And so she calls me and says, Ben, come try this case. I'm like, what's this case about again? So I had to jump in and try this case with her gone for a week.
Yeah.
And I cited to my cousin Vinny, as you can see here. But it was really, this is actually trial testimony of the opposing expert. And it was so helpful because Michelle did a phenomenal job in deposition, being so thorough with the expert. And this expert was saying ridiculous things that this podiatrist negligently put this screw right into her joint, right to where you're not supposed to put it. And this expert's like, oh, no, it clearly migrated over time. It went further into the toe over time, and which is just, it was baloney. And the radiographs, he's saying, oh, it proves it. Look at the radiographs, it's migrating. And so I just showed 3 radiographs of the patient without any dates on them, saying, hey, which one's which? Which date's which, doctor? You said it's migrating. Which one's which? And he couldn't do it. And so Michelle did such a great job in deposition that this really, really helped us win the case. Honestly, I mean, even though I came in and tried it when she came back the next week and did closing, did a great job, and we won the case.
I watched from remotely while he was, I think he took like 2 witnesses while I was gone. We played some testimony, but
yeah, and I'm like, Your Honor, I can look at my phone real fast. See if I mean, text messages from Ms. Hemesath if I missed any cross-examination questions. So I went back to my phone, and it's like just pages of questions, right? I'm like, I can't, no more questions, Your Honor. Thank you. Anyway, that was a fun trial.
it was, yeah.
Okay. What's next?
Let's see.
Same guy. He conceded that because the screws in the joint, which migrated, that she needed a second surgery. She didn't play it. Who cares?
I mean,
It's like helpful stuff, right?
So, yeah, I mean, again, this is just an example of you got to record your depositions. You got to play the helpful testimony in your closing. I don't know that we need to play the video.
There's a question from Andrew Morton says, what if a defense expert then uses the magic words to a reasonable degree of medical probability, but just says it was, listen, in my opinion, I think if the expert says more likely than not, or probable, or within standard of care, there's no magic language, guys. I mean, in my opinion.
Yeah, I mean, I think that, you should get that when you're deposing them later. Hey, it's your opinion. Is this your opinion to a reasonable degree of medical probability? So the question was about a declaration. We're going to talk a little bit about declarations later, but these can be helpful at the time of your deposition of an expert. And so Ben's right. I don't think that there's necessarily magic language, but sometimes that magic language, when you say it to the expert, then they're like, oh, well, maybe I can't say that to a reasonable degree of medical probability.
And sometimes you don't want to clean it up. All right. Because if you clean it up, now we know the defense lawyers draft the declarations, but they still review them, the experts, right? The more they clean it up, the more they know the law, and the less you can get out of them. Oftentimes, we'll go over this later, but we like to use declarations against the experts oftentimes, and so you don't want them to clean it up.
It's normal.
You gonna play it or not? Who cares?
No, this is the next one.
Yeah. This was a case that we tried, and the standard of care, and there's a little girl, 2-year-old girl, who had a bunch of, she had a condition called spina bifida. It was several years ago we tried this case. And the doctors, the ER doctors did not diagnose her with a shunt malfunction, which caused a bunch of fluid in her brain to build up, okay? And they sent her home. In the waiting room, before she even got into her car, she died, all right? And their causation expert was saying, oh, no, the fluid was already in her brain by the time she got there. It was too late. There's no way we could have done surgery. And the standard of care expert, Dr. Ritter, this guy, said, oh, no. She did not have fluid in her brain. There's no way she did. She would have been symptomatic. It would have been clear as day. And it was reasonable for doctors to miss it. So we have the two defense experts saying diametrically opposite things. And what we did too, oftentimes we'll actually just show the transcript of the depo in the closings. We'll play the video in our case, but we'll just show the transcript in our closing, because when you read it, you can emphasize different words. It can be more effective sometimes just to show the words. But yeah, just again, really helpful to have that. But because in trial, this expert backed away from his opinion and kind of softened it and said, you know what, I'll defer to a neurosurgeon, right? But now we had the depo transcript that we were able to use showing they can't even agree with each other, folks.
And that's why it's important to play their testimony in your case in chief, because otherwise they will soften that at the time of trial, and you're not going to get that same testimony. And so you can try to impeach the witness, but it makes it much more clean if you play it in your case in chief. And so they get to hear these two conflicting opinions, and they don't get to clean that up, right? So they've heard it in your case. Oh, these two people are saying totally different things. At trial, they're not going to say totally different things. And then in your closing, you can say, here's what he said. And here's what the other expert said. They can't even agree themselves, So that's why I think it's important that you understand that when you're going into these depositions, you are not just saying, okay, give me all of your opinions on the standard of care. Give me all of your opinions on causation, right? I mean, you need to be actively listening, questioning them so that you can get that testimony and soundbite that you need at trial.
There's a question. Does asking the defense expert during the initial admonitions whether they're here to offer their opinions to a reasonable medical probability cover the entire depo? Don't do that.
I wouldn't do
that. That would be incredibly stupid. I'm sorry. That'd be very, very foolish. Because now basically it's a softball. They'll say yes. And then now everything they say is probable, right? No. Wait till they give you the response so you can attack it. Don't give them a softball and then all of a sudden just authenticate all their opinions. That would be a big mistake.
And the reason that it's a mistake is, again, sometimes when you confront them on a specific opinion, they might say, well, no, I mean, it's a possibility. Exactly. I can't say if it's, more than 50%. I think it's, it's definitely between these three things or something along those lines. And so you want to wait for them to give you those opinions, and then you attack those opinions after they've given them to you.
For those that do mid-mal or just have a case here and there, be prepared for the defense to submit a motion in limine or file motion in limine that's extremely stupid, but can trick some judges that don't have a lot of civil or med-mal experience. And here, I'll show you the, let me put up the motion in limine right now. Here's the motion in limine on the left-hand side. This is the same motion that every defense firm files. In fact, there's a typo in this motion that I found in other defense motions, other firms. They share this motion. They file, and it's oftentimes number one, like you see here. This one that was just filed recently, a case you just settled a few weeks ago, and it's their motion is don't let the plaintiff expert ask about the personal practices of our expert, because oftentimes what the defense expert will say is, you know what, I think that this is acceptable, but I would never do it this way, right? Go ahead.
Yeah, and so, I mean, again, Ben said this motion in limine gets filed in every case, and it's oftentimes because they know that their experts are going to say they wouldn't do it this way or that they don't do it this way. And so that that's important. If you're have an expert on the other side that says, well, I wouldn't do it that way, but it's okay. It's within the standard of care. It's reasonable to do it another way. Well, they can, when you think back to 502, you know, you're thinking, what would a reasonably careful doctor do? Okay. And so are they saying that reasonably careful doctors would not do whatever it is that you're saying, but the defense expert, he's more careful. So we don't have to be as careful as the defense expert in his personal practice, but you know, the other doctors out there, they could be less careful.
Yeah,
That's
they're like,
still
oh,
within the
our
standard.
expert's an A plus and standard care requires only C grade, and therefore it's not relevant. That's baloney. There's no California case on point either way. There are like 30 cases in other jurisdictions that have all held, of course that's admissible. It goes directly to the expert's credibility, right? I would never do it that way, but it's within the standard of care. Come on. Of course it's relevant. Of course it's important. And in California, we need to have wide latitude to cross-examine opposing experts, particularly in med-mal cases where everything is defined by expert testimony. And it also goes to experience too, right? If they say, oh, I'd never do it that way, that also shows they're not experienced in doing it that way either, right? It goes to their experience, their qualifications. So to say that's not relevant, it's absolute baloney, but there's no cases directly on point under California law. So if you see this dumb motion, please email me and ask me for our form of opposition to this dumb motion. And it should be denied. And it has been ever since. I had it granted one time early on when I just thought there was no way the judge would grant that motion because it's so stupid. And the judge granted it unbelievably. And so then I did a deep dive into every single jurisdiction and drafted a very, very long opposition. And since then, it's never been granted. All right. And nor should it be. All right. So, you know, and it's really, really important. And it's not just as to decisions on what to do. It also goes to the recognized risk defense. So under KC 505, it's the most devastating instruction of all time. It should just say defense must win in med mal cases. It really just it's actually titled success not required. And it says basically doctors can screw up and it's not malpractice, right?
You should address that in your own closing. Do not let the first time that they hear that be in the defense's closing, okay? You need to emphasize this says that they still need to be reasonably careful. Don't be confused. This instruction is the same as 502.
And so when you cross-examine an expert at trial and deposition, make sure that you're prepared to address that. Doctor, it is recognized risk, right? And that's why you have to be ultra careful. You have to visualize the common bile duct before you cut in a lap chole. You have to be ultra cautious. You know that could be devastating circumstances or consequences if you do, you know, if this risk does happen. And then ask about that expert's personal experience and how often that risk has happened to him or her. And that's what Michelle did in this case.
And how many perforations have you had of the subclavian artery?
Oh, subclavian? I can't remember the last one. Probably very, very few, if any.
Okay, so as you sit here today, can you remember even one time where you perforated the subclavian artery?
Not offhand, no.
Okay, and so this case recognized risk when you undergo an angioplasty that you might have a perforation, okay? And my expert had to concede that. Yeah, it is a recognized risk. Well, how many times has it happened to you, doctor? Oh, can't even think of a time. Okay, so yes, there are recognized risks that happen, and that can still be malpractice. Oftentimes we'll do focus groups, and jurors sometimes will say, well, you know, it was one of the things that they knew about and it can happen. And so I don't really think there was malpractice. You need to combat that. And that's where these personal practices and what has happened in their experience, it's important to know. Okay. And you got to voir dire on that issue. But again, you have to ask the question or the jurors will never know about it. And so when you're preparing to depose these experts, you should also know the answer that your own expert is going to give. My own expert had said that he had not had a perforation of the subclavian artery. But But the breach here wasn't the perforation, it was the failure to recognize it. This is this artery is in a location where it is very difficult to get compression. And so a bleed is significant in that area. And that's why you have to be very cautious. And this bleed wasn't caught for 2 hours. And so again, when you're doing medical malpractice cases, you got to know the medicine. And then you have to use the medicine against the defense experts or the plaintiff's experts, whatever side you're on.
And always use car accidents as
You got to give more explanation than use car accidents.
well. Yeah, I mean, in your closing, be like, hey, is it a recognized risk that you'll get in a car accident when you drive to work? Of course. Does that mean that every car accident happens in the absence of negligence? Of course not. Right? So that's what we do. And then also, like, another big issue with the recognized risk defense is you always want to bring up the fact that, yeah, sure, doctor, it's your opinion that it can happen outside of negligence, absent negligence, but it can also happen with negligence too, right? And we won this case because the defense expert basically said, yo, yeah, I agree with that. It can happen if you're not looking. And I had her admit on the stand that she wasn't looking when this enormous skin tear occurred. And so he's basically supporting my case. And this won the case for us. This testimony right here won the case for us. So really important. We went over that already. Oh, all right. You want to go over this?
So this is my last trial that I was in. This is the defense expert, and I was asking him about the standard of care. So before we play this, when you prepare your expert for their deposition, I mean, it's important to make sure that they got all the materials. It's important to go over their opinions. It's also important to make sure that they know what to say if the other side's expert says, what is the definition of the standard of care to you? Just make sure they say reasonable. I mean, they don't have to know KC 502, but they do need to have reasonable somewhere in their answer, because otherwise you might get an answer like this.
How do you define the standard of care?
That's a good question. It's basically what 90% of emergency physicians would do given the same conditions.
Okay, so the standard of care is what 90% of ER physicians would do under similar circumstances?
High percentage, yes. I guess there may be something out there that says a different percentage. So I don't want to hang my hat on a 90%, but it's definitely not something egregious or something that was far off the mark.
So in order for a physician to violate the standard of care, does the conduct have to be egregious?
They would have to do something that was very atypical.
Okay, so in order for a physician to violate the standard of care, they have to do something that is very atypical.
Very atypical.
Okay, so you're never going to get that if you just read it. Oh, he's thinking about it for a really long time there. It's almost uncomfortable how long he's thinking about whether or not it has to be egregious. This is a poorly prepared expert, and how are we supposed to rely on this guy to say what the standard of care is when he himself doesn't know what it means?
We still lost that case, though.
We still lost that case because, medical malpractice cases are hard and people love doctors. The defendant in this case was a very likable emergency room physician. So, I do think these things are helpful. I talked to the jurors later. They thought that this guy was not great, but they just were like, well,
How do you define?
I think that this doctor did the best. I think emergency room cases are some of the hardest because these doctors are seeing so many patients, and it's an ER setting. So
I've never won an ER case. Never. Yeah. That's how good of a lawyer I am. All right. You can hold back general attack points. Yeah. Do you go over this stuff or not?
Just so
Well, let me see who's in the attendees. Any defense lawyers in here before I say anything? All right.
Well, so I mean, obviously during a deposition, you want to get the breakdown of the other side's experts' work. So do they do, 50-50, 100%, for one side? If they're doing 100% for one side, Ben's got a terrific example he's going to give you guys later to use. Have they worked with this firm before? And you should ask in your request reduction of documents to an expert to get their Rule 26 report or just a list of the cases that they've testified in before. And what I did in one of my trials was I knew that all of those cases were for the defense or they were a plaintiff's case that was out of state. And in a medical malpractice case, I think that's very important because doctors don't want to testify against other doctors who are in their community. And so I went through, I said, who did you represent in this case? And who did you represent in this case? And who did you, and he had previously testified that his breakdown, I think, was like 80-20 or 75-25. There was not one single case where he testified on behalf of a plaintiff in a medical malpractice case in California. And there was only like 2 cases outside of California. So his ratio really was not what he said that it was. And
Oftentimes that's a question. Can you name for me a single lawyer on the plaintiff side that's ever retained you? Just go ahead. In deposition, I'll ask that question. And then in trial, I'll rattle off every defense firm he's worked with. And I'll say, yeah, deposition, you couldn't even name for me a single time that you've testified on behalf of the plaintiff.
Obviously that works on the other side too for the defense attorneys that are out there.
And the records thing works on both sides too. I mean, guys, make sure your expert has everything. I make a huge deal at trial when I find out that the expert has not reviewed a deposition transcript. I'll show the deposition to the jury and I'll say, do you know why? The defense lawyer did not give you this transcript. Did they tell you that the transcript said X, Y, and Z? Had you known that, would that be important to you? Did you dig your head in the sand? Did you ignore that? Isn't more better than less when it comes to providing expert testimony? So, we go through our whole spiel when it comes to and also really important, depositions say, are you prepared to give me all of your opinions today? And then go over in detail what they reviewed and you lock them into their final opinions in deposition based on what they reviewed. But even if they reviewed that stuff after that bill before trial, you can still use that spiel. IMEs, I hate giving my defense lawyers but I love the IME is a gift. If you're a plaintiff lawyer and you see them call it an IME, don't correct them. Let them call it an IME, and in trial, just hammer them. So doctor, this is a true and correct report that you prepared, and everything you put in here is accurate, isn't that right? And your opinions in this case, and it accurately reflects your opinions, blah, blah, blah. The title says independent medical examination. I'm sorry, were you assigned or retained by the judge in this case, by a third party administrator? Who actually retained you in this case? Who paid you? Yeah, who actually does, and you go through all the whole spiel. And then I say, can we assume that the rest of this report is as accurate as you calling it an independent medical examination? So there's gifts that they can give you. We do say for trial. We're kind of running out of time. Can we just skip past this pie stuff?
Sure.
Okay.
I told them you were going to give them the example though. So
Yeah.
maybe just quickly.
I say I've got 2 boys at home and they love McDonald's pies. They love these pies. They do. They had them yesterday actually, and they don't finish them. I eat them, which is why I'm getting a little bit chubby. But they always fight over the pie, even though they don't even eat it all. But they say they were fighting over it. And how would I divide this pie if I was a fair and impartial parent? How would I divide the pie? Would I divide it like this? Because that's what the defense does, right? The defense has 95% defense work and 5% plaintiff work. Is that really fair and unbiased? So I use that. This is really important. It's embarrassing for me to show you this clip. It really is. This is a very emotional case for me. This is a case involving a very severely brain damaged child. I was very close to the family. We did settle this case eventually, but it was a fight. And you should always just stay calm and collected, right? I think, especially with experts, it's much better to be the disappointed mother versus angry, right? It's a much stronger approach, and jurors appreciate that more. They don't like the yelling and screaming and sarcastic comments. So I'm going to show you what not to do. based on what I did in this case, okay, in this deposition, all right? So don't do this in deposition or in trial, all right? Here we go.
The defense in this case, it states that you are expected to testify on issues regarding standard of care. Is that correct?
Yes.
Is it your medical opinion that the nurses in this case met the applicable standard of care?
Yes.
Is it your medical opinion in this case that the nurses followed all the policies and procedures at Loma Linda University, Murrieta?
It's my opinion that they followed the guidelines to the rationale that they needed to. Correct.
So the answer is yes.
I believe that they followed them to the reasonable level that they needed to. Yes.
Respectfully, it's a yes or no question. Did the nurses in this case follow the policies and procedures in place at Murrieta, Loma Linda, back in 2014?
It's not a yes or no answer. Guideline policy and procedures are guidelines, and therefore they're subject to nursing decision making and judgment and clinical thinking skills or critical thinking skills. I'm sorry, there's a bug.
I will move the strike as unresponsive. My yes or no question is this.
Ben, your motion's denied. And she answered the question, but you can answer.
Thank you, Judge. Thank you, Judge Cannon. Thank you, Judge Cannon. I know you think you know the law, even though you don't. Nurse Taylor, my question is this. Did the nurses in this case follow the policies and procedures in relation to hypoglycemia in place at Loma Linda Murrieta back in 2014? Yes or no?
Again, it's not a yes or no answer. If they use them as guidelines, then yes.
So the testimony the testimony is gold, right? I mean, clearly the nurses did not follow the policies and procedures. It resulted in this girl being brain damaged. It was a really sad case. And the actual testimony I got was gold, but I can't play that because I come off like a jerk. All right. Don't ever move to strike in a deposition. It's so stupid because then they can use that against you and they can actually join the motion or whatever. Don't do that stuff. Just be calm, be collected, talk slower than I did there. You know, that was supposed to be gold and it wasn't because of my attitude. And again, disappointed mother. That's the approach you want to use, not angry guy. All right. We have questions here. Are you ever able to get the defense expert to testify at depo before your expert testifies? Defense always forces plaintiff to put up their expert first, but I've never seen a code section or case on that. Great point, Joe.
There is not one. And they often say that there is no law that says that. And they'll also say, well, you know, we have priority if they do it first, but if they don't do it first, they say there's no such thing as priority. I think it's a gift. Honestly, your expert goes first and guess what? Their expert testifies to something and you always say, well, my expert may have additional opinions based on their review of your expert's testimony, and then they get to review that transcript. And guess what? Your expert might have additional opinions. And so you just message them and say, my expert has some additional opinions based on their review of your expert's testimony. I don't think that it matters. And I know that oftentimes defense counsel makes they say, well, you know, the burden is on you. Okay, but that doesn't mean my expert has to go first. But honestly,
I always say, counsel, don't worry. I'll play your expert's testimony in my case before my own expert. You have my word. They'll go first. Okay. And in fact, I have the burden. So it's even more important for me to question your guy first, right?
But I think it's fine. Honestly,
Yeah.
I usually just say, okay, great. Just understand that my expert might have additional opinions based on their review of your expert's testimony or based on their review of your expert's file. And so great, then you get the second bite at the apple and defense counsel has to pay for it. Whereas if you just say, oh, sorry, my expert has more opinions now, not based on some review of some additional testimony, well, then your expert should have had those opinions originally. And now you should, in theory, you should have to pay for it. So I don't think it's never a bother to me. I just produce them. But sometimes defense counsel will just say, hey, it's on whoever is available first.
Andrew, that's a very specific question regarding CDPH reports, kind of outside the scope of this presentation. Feel free to give me a call afterwards. Amber, you guys are so good at this. Thank you, Amber. Do you debate whether to file mills to exclude? No, we typically get along. I've debated with you more than I've debated with Michelle. I'm being dead serious. Okay, we'll move on.
You know what? And we'll just say that in terms of, is this some particular exclude anything or just exclude something in particular? Because when you say to exclude, I'm just assuming that you mean to exclude anything in particular.
I don't like
Is that what she's asking?
Well, consent forms, you always agree. You always include that. And consent forms you typically get out. They're not relevant to anything. What the patient consented to, especially when everything's defined by expert testimony, is not relevant. We can't cross-examine a consent form. So we agree in that.
Being on the case with the screw in the joint, we had some text messages between the plaintiff and the defendant podiatrist, who was like twice her age, was married, had kids, and there were like some texts that like he was inviting her out to eat and being very flirty with my client. And we thought they were gold. We thought, oh man, this is like, he looks, and we knew that he actually had a prior podiatry board case where he had touched a minor and had lost his license for a period of time. And so we were like, this is gold, right? He's a creep, but they're going to think he's a creep when they see these. Well, we did a focus group and some of the jurors were really turned off by these text messages. But on my client, oh, she's just upset because he didn't date her. So we're like, oh, defense wants to exclude these. We kind of fought it, but then not too hard. And then they got excluded, So I think if there's something that you want to exclude, you should really think about whether or not it is helpful or harmful to your case. And if you're not sure, or maybe you think you're sure, you should probably focus group it to see.
We knew that him touching a minor 20 years ago would never come in. And so, and we thought that these were creepy texts and that would we're biased because we know about the other minor stuff. And she was 21, he's 50. We thought this is gold. And the jury hated our client for it. The mock jury did. And so they filed a motion to eliminate, and we filed the weakest opposition of all time to maintain a appealable issue in case it got to that stage. But we were happy that it was out, and we won that case.
Should we answer the first question? Rachel's not.
How important is it to get very qualified experts for medical malpractice cases? Yeah, it's very, very important.
And of course, that comes from Rachel, who's wonderful. She's defense counsel in some of our cases. Listen, guys, it's hard on the plaintiff side to get experts because experts oftentimes don't want to testify against other physicians, especially physicians that are in their community. And if the jury just gets to see, doctor from UCLA testifying on behalf of the other side, and then you have, let's say, a solo practitioner that has never taught at an academic institution, well, who do they think is more qualified to testify about the standard of care? Well, it's going to be the doctor who is at UCLA, right? Because this doctor is teaching residents what to do. So it's very important that when you are getting an expert, that you try to get an expert that at least, they say they are an associate professor, but really that just means they might go and give a lecture once a year or something. You can't always get somebody who's not a solo practitioner, but it does help when you have somebody who is well published or has teaching credentials or has had decades of experience, and so yes, it's very important to get a well qualified expert, but well qualified also in the area that the defendant is in. Sometimes you get lucky and you don't need that, like we did in one of our trials.
No, we should have lost that case. We got lucky.
But again, the jurors are looking at this from no prior experience. They're coming in and hearing this stuff for the first time. So you need to think, if I knew nothing, who would I think is more qualified? But if the more qualified person comes off terribly,
guys, don't use experts from I'm sorry, I shouldn't say any.
Try not to
try to avoid people that that advertise. Okay. Yeah. I know, but on the defense side, my former boss, Robert McKenna, was phenomenal at just skewering the opposing experts on that issue. So don't do that.
Yeah, because they often say, hey, have you ever advertised for your services before? And then they'll pull up the places where they've advertised, and it just doesn't look good when they're advertising to be an expert witness versus this other doctor who's got privileges at UCLA or whatever academic institution. So.
Yeah, we have another great. We have really halfway through the presentation. We're not going to get close to being done, but I love this question. Scott Green asks, have you had instances where defense expert is deposed first and at trial refutes and disputes your expert's opinions via rebuttal and therefore was not obligated re Kennemore to be redeposed for additional opinion? Okay, that's a very loaded question. I'll say first that that's not rebuttal, clearly, all right? Rebuttal is a foundational issue. So disagreeing with an opinion is not rebuttal. So you would be right in objecting under that basis. However, how I read Kennemer and how I read De Palma versus Rodriguez is that the opposing experts required to give you all of their general opinions. You know, standard of care was met, causation, it wasn't the cause. They're not required to give you every little tiny itty bitty detail, right? And I think that disagreeing with your expert but still supporting their general opinion, I think passes the test, in my opinion. Now, it's a dangerous game to play because some judges will actually exclude that under Kennemer.
And to be clear, though, if they have an actual new opinion, let's
Yeah.
say your expert said,
Life expectancy.
okay, yes, or your expert said, the cause of the patient's death was some medical condition, and then the defense expert never addressed that medical condition, they can't later say, oh, well, they didn't have this medical condition because of A, B, C reasons, because that is a new opinion about that specific condition. So I think you could there argue that under Kennemer that additional opinion should not be allowed. I don't think you should wait until the person is on the stand, though. Like, this is something that you could put in a motion and eliminate to preclude them from offering this testimony. File it as late as possible so they can't now
It
say
sounds
they're
like a
gonna offer it.
surprise. Sounds like a
Yeah.
surprise at trial. I mean, yeah, and then obviously bring up Easterby versus Clark, which is a case that held that like you can tell the other side by way of letter, hey, my guy has new opinions, depose her or him again.
Well, so defense will always file these Kennemer motions, and I'm like, oh,
Join them.
great, join them.
Yeah.
But if you then have your own, like, oh, I know that the defense expert didn't address this specific point, you can file your own motion and eliminate, say the defense expert never, addressed this issue, and I think this should be excluded. If you have the foresight to understand that you think that that's what they may try to testify to later.
Be careful, guys, with declarations. Be really careful on both sides. Defense lawyer, plaintiff lawyer, be careful. All right. This is a declaration he signed before the defendant was even deposed. Really big mistake. Because I was able to just hammer him on it, right? Like, there's nothing that can change your mind, no matter what she said in deposition or in trial. And, so just be cautious. I have like half an hour more to say about this, but I have 2 minutes left, so I'm not going to say any more. We'll just get these are cool videos. I use timelines a lot during cross-examination of opposing experts, especially when that helps me. This is a case. I lose a lot of cases, man. I lost this case too. But I lost it. They were out for like 3 days at least. Like, they thought about it. But like, it shows the prior knowledge of my guy before he committed suicide. And so, the knowledge of the defendant. And so I did a timeline. You would agree, doctor, this happened, this happened, this happened. And oftentimes it's very helpful for the jury to see that as the kind of nice timeline before the closing statements, because oftentimes the opposing expert will be shortly before closings. Reverse Kennemer. This is really important. I have 2 minutes, just real fast. And this might be the most important slide.
We save for the end.
We saved for 2 minutes left. In medical malpractice cases, literature is so important, guys. It's so important. Do your homework. Ask your expert. Is there any literature on point? ACOG guidelines, anything at all.
Up to date. You need to know what they say. Do not have your expert say that something is reliable and authoritative if you yourself have not looked at it, because there may be things that are in there that are not helpful and are actually more harmful to you. So if you have an article that you get that you intend to use, make sure you read the whole thing. Make sure you understand it. Make sure you talk to your expert about it. Make sure you ask defense expert about any literature that they are relying on. Okay. And in my last trial, I had my own expert that gave me literature that I then used to cross-examine the defense expert, because the defense expert said, oh, these medications are only 30% effective. Well, I actually had a piece of literature from my expert that said that in fact, no, they are 90% effective. Okay. And so I was able to cross-examine him under 721 on that piece of literature. Okay. And so it's very important that if you have literature that is supportive in your case, that your expert identifies it as reliable and authoritative, and then you may cross-examine the defense expert on this issue.
Let's go over this again, okay? 721 BC says B3, not BC, B3, excuse me. You can cross an expert on literature that any expert, including your own, establishes as reliable authority. So typically speaking, most judges won't let your expert talk about and quote to, some publication out there that helps you. All right. They won't let you do that. But what you can do is have your expert establish a certain article or publication as reliable authority, and then you can cross the opposing expert on it. And what happens often
and you can publish it.
Yes, not in the evidence, but you can show it to a jury.
Oh, yeah.
And what will often happen is that the defense experts or lawyers can't help themselves and will cross your expert on it during your case. And then in redirect, you can guess what? They open the door. You bring on all that literature. It really helps you. It's almost an extra expert, right? So guys, 721, again, save the best for last, I guess, but 721B3 is critically important. And of course, this is obvious, but read all of the opposing experts' articles, see what they say, see what they're published, see if you can find other articles in those publications, find all the depositions, everything. So,
And then you can get them to establish, hey, you agree with this publication. Do you still hold the opinions that you held in this article that you published whenever it was, or do you still think this is reliable authority? And great, if they say it's no longer reliable authority, so what they said back, whatever, a year ago, 2 years ago, it's not reliable authority. So just you look through the publications. Sometimes experts have like 120 publications. It's a lot. Look through the ones that are pertinent to your case, or maybe pertinent to your case. And Jin Liu asked if we used AI to cross an
love you,
expert.
Jin. See you in Vegas.
I have not used AI to cross an expert. I have started using a court reporting agency that will allow you to look through a transcript, and you can like have that AI tell you like what are the inconsistencies in the testimony, what could you follow up on in other depositions. So I have used AI in the sense that one of the reporting agencies offers that, but I haven't just like gone out to
I have.
GPT.
I mean, I have a little bit. Hey, here's my question I'm going to ask. Any other question I should ask, or how should I phrase this? So it's helped me marginally, and I will use AI to dumb down things because I'm not smart enough to understand a lot of issues. So I'll be like, hey, dumb this. This is why I like Zoom depositions, by the way, because even though there is a benefit to doing things in person, it's nice to be able to just quickly throw medical terms or sentences into AI and be like, hey, dumb it down for me, please, in the middle of a next question. So I hope that answers that question.
If you have questions, because we are running along here, you can email myself or Ben. Our emails are very easy. It's just our first name and then at ih-llp.com. We're happy to answer any questions for you, or if you need examples of some motions, we can give those to you as well.
In retained surgical instrument cases, what strategies have been most effective in establishing liability? Typically speaking, we will actually force the defendants to point the finger at each other. And we filed motions on this very often. We'll do RFAs and SROGs both ways. Admit that the co-defendant, so basically, right, we have a doctor and we have the hospital, right? And whose responsibility was it to make sure a sponge or a forceps or whatever should not be left in the patient, right? So we'll actually ask the question both ways, both in RFAs and SROGs. We'll be like, admit that the hospital nurses met standard of care at all times. Admit they did not meet standard of care at all times. Do the same for SROGs also. And so we can force them to point the finger at each other. And that's oftentimes really helpful. And they'll refuse to point the finger, which is great. We'll settle with one of them, and then they're stuck with those responses for the purpose of trial. And if they try to amend them at trial, we can show the prior responses, right? So there's other strategies too when it comes to retained instrument cases. Just give me a call and I'll go that with you. Heather, I'll answer your question since you're at my firm. We have that's it. I guess we could have gone over a lot more stuff, but
thank you guys for attending. And again, if you have any questions that you didn't get answered here or that you want to speak to one of us individually, just reach out and we'd be happy to talk to you.
Any other questions? Are we done?
I think we're done. Yeah.
They forced us out of there? Like we're already past the time?
We're good. Thank you both so much for your time today. We really appreciate you speaking to our members, and I hope our members have a great rest of their day.
Okay, that's for sure done now. Okay, thanks guys.
Thank you.